fighting for me and keep showing your love and support.
Hello. First and foremost, welcome everybody. Hopefully everyone can hear me okay. I know that I was listening to the last couple of these lives and I noticed that I was having internet issues. And so let me check on something. So I'm going to play a video real quick. I'm going to check on something. So hold on 1 second. Here, let's listen to this.
We saw things that I think have never been seen before in a court of law. I can't think of another case where a defense attorney and his investigator plotted to pressure their client to plead guilty to a case that in which he was expressing his innocence.
That tape was somewhat disturbing, I think.
It was extraordinarily disturbing, and Michael O'Kelly is a seasoned investigator, and I believe what he did to Brendan Dassey traumatized him.
The first question you have to ask yourself is, do you want to spend the rest?
Okay, so I sound pretty good. So I'm just going to go ahead and continue. So we've been reading from The Anatomy of a False Confession by Michael Cincinnati, and we basically got like six chapters left. So I'm pretty much going to just like push through and just finish up these last chapters, and then we're going to be done with this book. And yeah, I hope that everyone has been enjoying me trying to read out loud for the class, and I hope you've all learned something. I know I've learned a lot by this, and yeah. So without further ado, I'm on page 171, and you can find this book on Amazon though, and I suggest that if you've been enjoying me reading these books, you should totally buy the book and support the author and read it yourself, because these books are really awesome, and my reading them does not do quite enough justice for how awesome especially this book is, because this book perfectly, in my opinion, breaks down what happened and what went wrong, and it explains it. All right, gotta stop yawning. Okay, so I'm just gonna go ahead and read. So chapter 32, Reforming Miranda, page 171. How do we begin reforming the system to protect innocent suspects from falsely confessing? The logical place to start is with the Miranda warning. Chapter 6 explained why the interrogator is the worst person to read the suspect his Miranda rights. The interrogator's interests are at the direct odds with the suspect's. That is, the interrogator's goal is to get the suspect to waive the right to remain silent and the right to a lawyer. However, it is nearly always in the suspect's best interest to invoke one or more of those rights. Chapter 7 and 8 then demonstrated how this conflict of interest plays out, because interrogators are motivated to get the suspect talking. They have developed numerous strategies to avoid reading the Miranda warning in the first place and to induce the suspect to waive those rights when they do read it. These tactics include minimizing the importance of the warning, reading the warning quickly to reduce the suspect's comprehension of it, and not giving the suspect the option of actually invoking the rights described in the warning. Then there are the problems with the warning itself. As previous chapters also explained, many versions of the warning are intentionally inconsistent and nonsensical, and most versions leave out important information that the suspect would need in order to make an informed decision about whether to invoke the rights. But even in the best case scenario, a slow, clear reading of a good version of the warning, Miranda simply contains too much information for an overwhelmed suspect to absorb and process at one time. And bombarding a suspect with all the information at once further reduces comprehension. More specifically, different rights are relevant at different stages of the suspect's police encounter. For example, the right to stop answering questions once questioning has begun cannot possibly become an issue until the suspect has decided to waive his rights to silence in the first place. Similarly, the right to have an attorney present during questioning is a moot point if the suspect decides to invoke his right to silence. Given the numerous problems with the existing Miranda warning and the way interrogators present it to the suspects, the following section proposes a new Miranda warning. This warning could be adapted at the local level by law enforcement agencies that are concerned about false confessions and wrongful convictions. But because the police do not want the suspects to understand and invoke their rights, this is not likely to happen. Fortunately, however, the new warning could and should be adapted at the state level by state legislators or Supreme Courts. And of course, the new warning should also be adapted on a national level. The United States Supreme Court already requires the police to read suspects a Miranda warning. It could easily require them to read a meaningful one. Hey, Carrie! I first proposed this new Miranda warning in my article, appropriately titled The New Miranda Warning, published in the Southern Methodist University Law Review in 2012. This chapter reduces a portion of that article with minor modifications. The purpose warning is broken into 3 forms. Each form contains a language that the interrogator would be required to read to the suspect. Each form then includes additional instructions for the interrogator to follow. Finally, following each form is a discussion section intended for the reader of this book, not the interrogator, that explains how the part of the proposed warning is designed to constrain police abuse, to communicate the suspect's rights more clearly, or to otherwise improve the Miranda process. The proposed Miranda warning begins with Form 1, and if necessary, proceeds to the additional forms after that. Miranda Warning Form 1. I would like to ask you questions about describe the reason for questioning. Before I ask you questions, however, I need to inform you of some very important rights that you have. First, you have the right to remain silent. If you decide to talk to me about anything you say, it can be used against you in court. However, if you decide to remain silent, your silence cannot be used against you in any way. That's what they say, but we all know that they try to guilt you and say, oh, if you're silent, then you must be guilty. We know that trick, right? Hold on, let me do something real quick, because this keeps happening and it bothers me. Sorry, it's my computer. Every time I let the mouse sit, the screensaver comes on after like 5 minutes, and I hate that. I don't like it when that happens. So hold on. Let me do something. Unplugged in PC goes to sleep after never. When plugged in and turn on after never. There. That should take care of that. Hey, Don. Welcome. All right. Now it shouldn't go black on me. I hate it when that does that, when computers do that. Like, I don't believe in screensavers. I think it's a waste of time, for me at least. All right. Okay. If you know that you want to remain silent, I will stop the interrogation now. But if you want to talk to me, or if you're not sure whether you want to talk to me, I will tell you about some additional rights that you have before you make your decision. Suspects should check only one box. I want to remain silent, and I understand that my silence cannot be used against me in any way. Or, I might want to talk to you and answer your questions. Please tell me more information about my other rights before I decide. Instructions to interrogator. If the suspect has checked the first box and elected to remain silent, end the interrogation now. If the suspect checked the second box, proceed to Form 2 and explain the additional Miranda rights. Discussion form of 1. So this is for us, not for the interrogator. That's what he was. Telling the suspect that the rights are very important will alert him that these are not mere bureaucratic formalities, but instead they are worthy of his full attention. For this same reason, it is critical to require the police to present the form in writing and read it verbatim. Any supplementing of the form with additional misinformation could easily defeat Miranda purpose. Because remember, guys, in the state of Wisconsin, you don't have to read the Miranda rights as they are. You can verbatim them, and that's why it was so confusing for Brendan, because he said a lawyer will be appointed to you in court, but not now, but we have no way of getting you one now. Like, that's confusing to tell somebody, even an adult. Right? But that's not exactly what Miranda rights are saying. Miranda rights are saying you were appointed a lawyer. Now, we will stop this and we will get you a lawyer now, not wait until court. Further taking away from creative liberties of the police by requiring a verbatim reading is not overly burdensome, while refraining from additional, often contradictory commentary is a bit more challenging for the police. They are capable of such restraint, especially with the threat of suppression of the suspect's statements looming over their heads. The heart of this form then advised the suspect of his rights to remain silent and that anything he says can't be used against him, not for him, in the court. Just as importantly, however, it also advised the suspect that his silence cannot be used against him in any way. This provides full information about the consequences of the suspect's decision and thwarts any implication that talking can somehow be the suspect's benefit or that not talking could be his detriment. This form also tells the suspect that will happen if he chooses to remain silent. The interrogation will end, and then it instructs him precisely how to affirmatively invoke the right. Check the box. Importantly, this form provides the suspect with a true choice, unlike many police forms that provide only descriptive to sign and waive the rights with no alternative. Part 1 of the new Miranda warning focuses on and stops with the first of the Miranda rights. This tiered structure puts the spotlight squarely on the only relevant topic at this point in the suspect's police encounter: the right to remain silent. If the suspect chooses to invoke this right, then the other rights do not apply. There is no reason to inform him of his right to stop answering questions because he just elected not to answer any questions. He will be informed of his right to an attorney and may even be appointed an attorney when he is brought to court, and there is no need to inform him of his right to have an attorney present at the interrogation in which he just declined to partake. Further, by ignoring these presently irrelevant rights, we avoid using a warning that is long, complex, and obscures the right to remain silent. Miranda Warning Form 2. So this is if somebody, before they said check 1, I wish to remain silent. Check 2, I might want to talk to you and answer your questions. Please tell me more. So the next part, Form 2, is when you say, I might want to answer your questions. Please tell me more. So Miranda Warning Form 2. I will now inform you about your additional rights that you have. You have the right to an attorney. If you cannot afford an attorney, the judge will appoint you one for free if and when you go to court. You have the right to consult with your attorney before you decide whether you want to talk to me. If you consult with your attorney and decide to talk to me, you have the right to your attorney with you when you talk to me. Suspects should check only one box. Knowing these additional rights, I want to remain silent, and I understand that my silence cannot be used against me in any way. Or, I understand that these additional rights, but I want to talk to you and answer your questions now without an attorney. That's a very good thing, saying I'm okay to talk to you without an attorney. Instructions to interrogator. If the suspect checked the first box and elect to remain silent, end the interrogation now. If the suspect checked the second box, proceed to Form 3. And then here's the discussion of Form 2, which is just for us. Because the suspect did not invoke the right to silence after reading the first form, the information in Form 2 becomes relevant. It informs the suspect of all those suspects of the right to counsel, the right to counsel itself, the right to court-appointed counsel for the indigent, and the right to consult with counsel before and during any statements to police, and then given the suspect the additional option of remaining silent or talking to the police rather than directive to waive the right to speak. Importantly, this form does not state or even imply that this is the suspect's last chance to talk to police, or conversely, that if he chooses to talk to police, any attorney will be made available on the spot. The police have no way of providing counsel prior to or during the interrogation, nor are they obligated to do so. This form is therefore both complete. Therefore both complete and accurate with regard to underlying rights and procedure. Miranda warning Form 3. So this is if he checked the second option, which was, I understand these additional rights, but I want to talk to you still. So then the police would say this. I have told you that you want to give up certain rights and talk to me. I will need you to sign and fill the information below before we get started. The rights that you are giving up by talking to me are the right to remain silent. Again, if you decide to remain silent, that cannot be used against you. The right to consult with an attorney before and during questioning. Waiver of rights. I have decided to talk to you about described reason for questioning. I understand that anything I say can be used against me in court. Finally, I also understand that I can change my mind and stop the interrogation at any time by telling you I want to stop answering questions. And then suspect to sign date and time here. Discussion Form of 3. This form recaps the rights the suspect is giving up, reminds him that anything he says can be used against him, and the documents of the waiver in writing. Most specifically, it informs the suspect that the last of the Miranda warnings, the right to stop talking at any time. While reforming Miranda is a big step in protecting suspects from coercive police interrogations and false confessions, it is just the beginning. As the next chapter explains, in cases where suspects waive their rights and decides to speak, reforms are desperately needed for the post-Miranda interrogation as well. And that was the end of chapter 32, and now we're on to chapter 33, page 177. And this is also a 2-page thing, so it's not that long. Role-playing the interrogators. While the last chapter offered a highly specific and easily implemented reform measure, this chapter takes a different approach. It builds upon the framework that is currently used to decide whether a confession is admissible at trial. In doing so, it highlights the fundamental flaw in the way the courts analyze this issue. Earlier chapters explain that the police interrogate a suspect and obtain a confession. Whether the confession is admissible at the suspect turned defendant trials depends on whether the statement was voluntary. The statement is voluntary when a suspect made a rational choice to confess. The statement is not voluntary when, example, the interrogators dub the suspect with false information that prevents him from making a rational choice. And the most common way interrogators interfere with a suspect's ability to make a rational decision is to play the role of the defense lawyer. Despite their warning that anything you say can be used against you, Wieger and Fassbender seamlessly slipped into the opposite role and played Dassey's advocate. Then, after winning his trust, they provided him with bad advice specifically designed to prevent him from making a rational choice. For example, the interrogators assured Dassey that talking was in his best interest. In fact, it was required if he wanted their protection from the bad government agents who supposedly were going to prosecute him. The interrogators told him that they had a lot of evidence and already knew what happened. They also told him that even if he admitted to helping Avery commit the crimes, he'd still be better off if he confessed. They repeatedly told him the crime was not his fault, rather it was Avery's fault, and they convinced him that if he just confessed his involvement they already knew about, he could put his case behind him and even get back to school. After ripping through Miranda warning at the squad car on the fateful day of March 1st, 2006. Hey! Megan? Wiegert said, "Alright, so, like I told you, we're going to take a ride over to the Manitowoc Sheriff Department. They got a nice quiet room there. There's no kids running in and out and stuff, so if you play it right, who knows, maybe we'll get you back as soon as we can. If we all get over there as soon as we can. I'm just gonna have you initial actually here and here saying that I read you those rights and that you agreed to talk to us, okay? Alright. We know two things for sure. The interrogators believe that playing the role of Dassey's advocate would work. Why else would they have spent all that time building his trust and then lying to him about the consequences of making a statement? And second, we know that playing the role of Dassey's advocate in fact worked. He trusted them, believed them, and clearly thought he was going back to school after he gave them the statement they wanted. Despite all of this, the trial court and the state appellate court found Dassey's statement was voluntary, the product of a free and rational choice. As I argued before, these courts were merely rubber stamps designed to aid the state in obtaining and preserving its conviction, then nothing, I suppose, in this chapter would change that. The other hand, if I am wrong and these courts actually made a good faith effort in arriving at a reasonable decision, then their absurd conclusion that the interrogators' lies and promises did not interfere with Dassey's rational decision-making process proves that the legal framework for this analysis is defective. Instead of existing framework, then we should be using this framework when the interrogators want to play the role of suspect's defense lawyer. They should be held up to the same standard as a suspect's defense lawyer. Imagine, for example, that instead of talking to Wiegert and Fassbender, Dassey had mustered the courage to tell them to get lost and instead hired a lawyer. Then pretended that the state charged Dassey with rape, murder, and mutilation of a corpse, even though it had no physical evidence, eyewitnesses, or in this hypothetical scenario, confession. Finally, imagine that Dassey's hypothetical lawyer gave him advice without entering a plea deal in the court that was similar to the advice Wiegert and Fassbender gave him about admitting guilt in the interrogation room. That is, just as Wiegert and Fassbender urged Dassey to disagree the Miranda warning they just read him, the supposed defense lawyer urged Dassey to disregard the warning in the plea form. Brendan, the form you're signing states that you would be sent to prison if you plead to these crimes. But don't worry, that's not true. That's just meaningless boilerplate. You will help yourself by pleading guilty in court. Similarly, just as Wiegert and Fassbender told Dassey he was not legally responsible for assisting Avery, and therefore he could tell them anything and everything without consequence, suppose the defense lawyer gave Dassey similar advice. Brendan, the law says that because this whole thing was Avery's idea, only he can be held responsible. So even if you plead guilty, thereby admitting to the judge that you helped Avery, you're going to be okay. Finally, just as Wiegert and Fassbender lied to Dassey about the evidence they had and what they would and wouldn't happen if he simply told them what they already knew, suppose the defense lawyer did the same thing. Brendan, the state has DNA evidence that proves you're guilty, or proves your guilt, and we already know what happened here. You did help Avery, but again, these crimes are on him. So just admit your role by pleading guilty and we can get back to school. You know, what's funny is O'Kelly said these similar things to Brendan during his quote-unquote interview or interrogation of Brendan. I don't know how Kaczynski didn't get ineffective counsel. I don't understand that. Anyway, if Dassey had admitted guilt in court based on this type of advice, his inevitable question to the judge, do you think I could get back to school by 129, would have been met with a smirk and an armed escort to prison. However, if things had actually played out that way, Dassey also would have been allowed to withdraw his plea deal. Why? Because his hypothetical defense attorney's performance would have been ineffective. The attorney's advice would not have lived up to the guarantee described in the Strickland versus Washington. Rather, such advice, 1, would not have been accurate, and 2, would have affected Dassey's rational decision-making process with regard to whether he should plead guilty in court. The questions then are these. If Wiegert and Fassbender are allowed to dub a child by playing the role of his advocate, why shouldn't they be held to the same standard as a defense lawyer? Why shouldn't the dubbed child be allowed to withdraw his confession just as misinformed defendant would be allowed to withdraw his plea? If Wiegert and Fassbender had been held to the standard, a standard quite appropriate for the role they were playing, their misinformation would have rendered Dassey's statements involuntary and therefore indemnifiable in court. This line of thinking, while rational, is admittedly outside the proverbial box. So for a more realistic reform recommendation involving the government's use of the defendant's statements, we must now move from the interrogation room to the courtroom. And that's the end of chapter 33. And now we begin chapter 34, false confession experts at trial. Before 2011, whenever a Wisconsin prosecutor wanted to use an expert witness to help convict a defendant at trial, the expert merely had to pass the mirror test. If the judge put a mirror by the expert's nose and mouth and the mirror fogged up, the expert could testify. Oh, that's sad. You had to be living with a heartbeat, I guess. The prosecutor had a so-called expert on call just for about every situation. For each type of case, for example, child abuse, domestic violence, or drug possession, the prosecutor would file the same useless, canned, typo-ridden summary of expert testimony, no matter the facts in the particular case being tried. Did the alleged victim delay reporting the crime until several months or even years later? There's an expert for that. Such delayed reporting is very common among victims of a crime for which the defendant is being prosecuted. Did the alleged victim recant the allegations by saying he or she made it up while in a drunken state of anger? Don't worry, there's an expert for that too. Recantations are very common among victims who often are forced by defendants to recant the truth. Did the defendant refuse to answer the questions when approached by the police? There's definitely an expert for that. Such pre-Miranda silence demonstrates a consciousness of guilt and is very common among people who commit the type of crime for which the defendant is on trial. But the law states that whether a witness testimony is true and whether the defendant is guilty are matters to be decided by the jury, not the government agent or the victim advocate posing as an expert. So the way prosecutors got away with this scam was to stop just short of having the expert testify, for example, that the victim's initial accusation, not the recantation, is true, or the defendant is a liar. Yeah, mine does too, Don. Instead, the expert would give his or her spiel to the jury, and then the prosecutor would repeat that testimony in closing arguments to convince the jury, through argument, that the defendant is guilty. It's hyper-technical distinction, and one that makes no sense anywhere outside of the appealing court decisions. But the bigger problem is that these experts weren't experts at all. Not only were they typical full-time government employees, but they had little, if any, interest in truth. Instead, they're chameleon-like creatures, changing their testimony to fit the facts of any given case to help the prosecutor win a conviction. For example, Suppose the alleged victim immediately reported the alleged crime rather than delaying his or her report. The expert would now testify that immediate reporting was very common, and the phenomenon of delay reporting suddenly became merely possible or something that could be common. Similarly, suppose the alleged victim did not recant the accusation, but instead changed the detail of the incident, adding them as time passed. The expert would now brand this mode of piecemeal reporting as very common. Recantations, although previously a commonality, are now described as anomalous. Anomalous. And most chameleon-like experts of all were the police. Suppose that instead of clamming up upon seeing the police, the defendant became nervous and talkative. This behavior, according to the officer's testimony, was suddenly a sign of a guilty mind, while silence was less common phenomenon. Then in 2011, the law changed in Wisconsin. Instead of the wild frontier anything goes approach to expert witnesses, the trial judge was supposed to be a gatekeeper of sorts. By adopting the more stringent federal Dombert standard of admissibility, judges were supposed to shield jurors from Fox experts who modify their testimony to suit the prosecutor's needs. Prosecutors were quite obviously not the ones driving this change to the Dombert standard. They liked things exactly as they were, and the criminal defense bar certainly didn't have the clout to bring about this type of change. I don't know who had advocated for this legal reform. The rules on expert testimony also apply to civil cases, so I suspect the big business was sailing the ship of change. But many criminal defense lawyers were hopeful that Dombert would change things for the better. Many thought it might put an end to the state's practice of using a government agent or victim advocate to put the gloss of expert testimony on any otherwise weak government case. I, however, complained aloud that this new law would change nothing for the prosecutor, would only create obstacles for defense lawyers. And I was right. First, with regarding to the prosecutor's use of these types of experts. In theory, Wisconsin's new test for admissibility of expert testimony is flex but has teeth. In practice, it's flexible and has dentures. Literally every defense challenge litigated on appeal since Dombert became effective has failed. The Court of Appeals has held that expert testimony regarding the renegade exploitation of a person's blood alcohol concentration passes Dombert. So does the doctor's testimony based solely on his personal experiences with prenatal and delivery case. So does the social worker's testimony based solely on her observations of behavior in child abuse victims. And now so does expert testimony by drug recognition evaluator. In other words, the law changed nothing on the prosecutorial side. To use one of the above examples, Wisconsin courts are still allowing government social workers to testify based solely on their personal. That's what it means. I can't say the word, but it means personal experiences about the commonalities of abused children. And then based on that testimony, the prosecutor is still arguing that the child in the case being tried is truly a victim and therefore the defendant is guilty. But what about the defendant's false confession experts? Given the above examples, how easily the state's expert passed the new Dombert test, and should be slam dunk that false confession experts are allowed to testify for the defense, right? False confession experts are experts in the truest sense of the word. They have PhDs in psychology. They conduct studies that the test hypothesis. I don't know why. I cannot words. Their testimony is based on research that is actually published. They have specialized knowledge about the police interrogation tactics and suspects' personal characteristics that are correlated with known false confessions. They have studied false confessions both in real-life criminal cases and in controlled experiments. In short, these witnesses can debunk the state's sophistry in closing arguments where the prosecutor cries out to the jury, people who are innocent don't confess. Remember, Ken Kratz said that? Of course, despite their frequent claim that trials are a search for the truth, prosecutors vigorously oppose defendants' use of false confessions experts. Prosecutorial arguments to prevent them from testifying are tried, recycled, invalid, and even nonsensical. There are three types of these most common. First, before an expert is allowed to testify at trial, he or she must possess specialized knowledge outside the jury's common knowledge. And this makes sense because if the so-called expert topic is already within the jury's common knowledge, then there's no need for an expert. Given this, prosecutors shamelessly argue that the phenomenon of false confessions and the factors that are correlated with them already fall within the juror's common knowledge. This argument can only be described as disingenuous. If false confessions and their causes are within the common knowledge of the typical jury, wouldn't psychologists with PhDs find better things to do with their time? Why would they keep studying something that is known and understood not only within the scientific community but also in the non-experts that sit on juries? And if the body of research is false confessions was already common knowledge, why would prosecutors argue to juries that people who are innocent don't confess? If they're commonly known, as prosecutors contend, that innocent people do confess, then prosecutors would not contradict common sense and argue the opposite to the jury. In reality, of course, the commonly held but enormously believed is that an innocent person would never admit to something he didn't do. Prosecutors craft their arguments to take advantage of this misconception, and false confession experts are needed to debunk this fallacy. Even empirical evidence supports the obvious conclusion that false confession experts have knowledge falling outside of jurors' common knowledge. In a published study-turned-article, Danielle Konacki, Lawrence T. White, and I empirically demonstrate that even highly educated survey respondents held serious misconceptions about false confessions and the interrogation tactics that produce them. In other words, there is a large gap between 1, common knowledge of juror-eligible citizens, and 2, the specialized knowledge that PhDs have acquired by reading published studies and conducting their own research. There are no surprises here. So let's move on to the next prosecutorial argument. Second, prosecutors have literally argued that false confession experts should be prevented from testifying because they might confuse the jury. How? Juries might believe that the suspect turned defendant's confession is false. The problems with this argument are as obvious as the argument is invalid. It is true that the law does not permit the judge to exclude marginally relevant evidence when it is outweighed by the risk of jury confusion. However, the state's argument that a false confession expert would confuse the jury misuse the words jury confusion, something that could happen when the jury hears evidence not directly related to the charged crime. The described possibility that the jury might acquit the defendant of the charged crime. In other words, the state begins by assuming the very thing that has to prove at trial, the defendant is guilty, and then argues that any defense evidence challenging this assumption is confusing. The prosecutor might as well remove this thin disguise and simply say what he means. Any evidence that could raise reasonable doubt about this defendant's guilt should be excluded. The next step, of course, would be to skip the trial entirely and simply ask the defendant whether he pleads guilty or really guilty to charge the crime. The third and final, prosecutors also oppose the use of false confession experts by arguing that even if the body of research on false confessions is specialized knowledge, the expert is not able to tell the jury whether his particular defendant the one on trial, falsely confessed. Well, that's true, but this argument overlooks two things. By comparison, when the prosecutor calls an expert witness to testify, for example, about the factors associated with the victim recantations, that expert is not capable of determining whether the particular alleged victim who testified at trial lied when making the initial accusation or lied when recanting in court. Despite this, the expert is still allowed to testify. Additionally, whether a defendant lied when admitting guilt in the interrogation room or when denying guilt at trial is an issue for jury, not the expert to decide. The law specifically prohibits a false confession expert from testifying about whether and when this particular defendant was not telling the truth. Whether the prosecutors were arguing that the false confession experts could not be allowed to testify because they are incapable of doing that the law prevents them from doing anyway. This argument is absurd as the prosecutor's first two arguments. But what does all of this have to do with legal reform? In cases where the state uses the defendant's confession as evidence against him, and the defendant claims that he falsely confessed, defense counsel must be permitted to call a qualified expert witness to discuss the case, the body of research on false confessions. The expert's role is to educate the jury, not to opine whether the particular confession at issue is false. Deciding the truth or falsity is the jury's role. However, it cannot properly do this when they labor under the misconception that innocent people do not confess. Given that the Miranda interrogation reform discussed in the previous two chapters are likely not to happen, allowing false confession experts to testify at trial may be the best way to prevent a defendant's false confession from turning into a wrongful conviction, and a wrongful conviction from turning into a prison sentence. But this proposed legal reform, while realistic, is still hypothetical. The next chapter, therefore, takes us back to interrogation room for something a little bit more promising. And that's the end of chapter 34. Does anybody have any questions before I continue? We literally got 3 chapters left in this book, and they're only 2, 3. I don't even think anybody's watching. 4. Oh, hey Don, you're still watching. 5, 6, 7, 8, 9. And we only got 9 pages left. So that's why I want to just push through and get this book done and over with, and then next Monday we can start a different book. But thank you. I know I stumble over the big words here. I have issues with pronunciation. But as long as you guys are understanding what I'm saying, that's what matters. Yeah, these chapters are very short. The book itself isn't very long. Let's see. If I joke, innocent don't confess. How do they lay their heads? I know. And they know just as well as any expert that Brendan. Oh, hey Megan, you are listening too. Yeah, it says only one person's watching, so that's why sometimes it's hard. But I appreciate anybody who does watch. So I do thank you guys for being here. But yeah, it doesn't take an expert to see that Brendan didn't, he was a false confession. Like, a lot of non-experts watched the documentary, watched his interrogations, and can plainly see that this kid was being manipulated and coerced into saying what he did. And I think that it is ridiculous that a prosecutor can stand up there and spew bullshit and call it facts. Like, innocent people don't confess to things that they didn't do when it happens all the time. I mean, you see it in the news nowadays more than anything. People are constantly being released from prison after doing 20 years, 10, 15, 20 years in prison for something they didn't do. So, I mean, it does happen. And unfortunately, it happens all the time. And I say this, and I mean it. Brendan's case is not the first where it comes to a minor. And it's probably not going to be the last unless we do something in this country to prevent it. And some states are starting to do that. And that's really awesome. Some states are starting to adapt you're not allowed to lie to a juvenile, which I think is a great start. I think that I don't think that any detective should lie to anybody, though. I think that lying, telling anybody that they have evidence against you when they clearly don't. And I think it should be required from the get-go. I don't think you should be able to waive your right to the right to have a lawyer. I know that we're all allowed to make decisions as adults, but I think you should always have a lawyer with you no matter what. And I think even if you say, oh yeah, I'll talk to you without a lawyer, I think that this should still be required to have a lawyer with you. So that's just my personal opinion. I'm going to play a video real quick, and I'm going to use the bathroom because I have to pee. So I'm going to go ahead and play a video real quick. So let's take like a 5-minute break. Let's play this video.
You were appointed, was it on March 7th or March 8th?
March 7th.
March 7th, okay. Did you talk to Brendan on that day on March 7th?
I don't believe I did.
Okay. However, you did talk to the press, is that right?
Yeah, shortly after the appointment, the calls started rolling into the office.
Sure. I want to draw your attention to a news report from Channel 26 that says we have a 16-year-old who, while morally and legally responsible, was heavily influenced by someone that can only be described as something close to evil incarnate. Right?
That's what it says I said, but that wasn't me.
Okay. Is there anything about this statement that bothers you?
To say that we have a 16-year-old who's morally and legally responsible, that would in effect admit guilt, and that is something you should definitely not say.
Just for the record, Your Honor, Mr. Kaczynski testified that he did not make those comments, and this exhibit is being introduced as impeachment evidence to demonstrate that, in fact, Mr. Kaczynski made those comments.
The court will receive it.
Attorney Len Kaczynski immediately lashed out at Stephen Avery.
We have a 16-year-old who, while morally and legally responsible, was heavily influenced by someone that can only be described as something close to evil incarnate.
And the next day, you make the statement that if the confession is valid and admissible as evidence, it would almost certainly result in a conviction. Correct. Okay. You still have reviewed Brendan's statement, right?
No, that's correct.
First statement?
Correct.
All right. March 10th.
The rules that Governor Evers has issued say nothing about restricting his ability to issue commutations. A commutation is the shortening of a sentence, and so that's one option on the table still for Brendan Dassey. And as for his rules regarding pardons, those rules say nothing about the case of someone who is actually innocent, like Brendan Dassey. When you have an innocent person sentenced to life behind prison, that's exactly the situation that the clemency power was tailor-made to address. This is a case that federal judges have called a profound miscarriage of justice, and we're calling on Governor Evers to remedy that injustice today.
We saw things that I think have never been seen before in a court of law. I can't think of another case where a defense attorney and his investigator plotted to pressure their client to plead guilty to a case that in which he was expressing his innocence.
That tape was somewhat disturbing, I think.
It was extraordinarily disturbing, and Michael O'Kelly is a seasoned investigator, and I believe what he did to Brendan Dassey traumatized him.
All right, that was the right one. Okay. I'm back. The real reason why I have those videos up is so I can go use the bathroom and not have dead air. Okay. All right. Let us continue. So we're on page 187, chapter 35, Bye-Bye Read. We've got 9 pages left, and then we're done with the book. So let's get going. All right. There are other types of legal reform that is more than a mere possibility. It's actually underway in the real world. This reform involves making several changes to the way police interrogate their suspects. Chapter 4 explained that interrogations are a guilt presumptive process. The police aren't there to learn information, but rather to get the suspect to admit that he's guilty. Numerous of other chapters in this book expose the tactics that police use to reach that goal. For most part, the police don't dream up these interrogation ploys on their own. Rather, they are formally trained in them. And the current and most popular method of this training is known as the read technique. Boo, hiss. The dominant school thought on interrogation tactics since the 1960s distills into the manual known as the read technique. holds that detectives should relentlessly cajole their suspects towards their own set theory of the crime in question. This approach presumes the interrogator has made no mistakes and can pressure their chosen perpetrator into a confession to match the interrogator's narrative. It also presumes that a confession is an absolute sign of guilt and that the innocent people do not falsely confess. This is a convenient presumption, of course, but one that has now been thoroughly debunked. The good news is that change is afoot. One of the nation's largest police consulting firms, the one that has trained hundreds of thousands of cops from Chicago to New York and federal agencies at almost every major agency, said it's tossing out the Reed technique because of the risk of false confessions. The consulting firm, Wickerland, Zulowski, and Associates now recognize that confrontation is not an effective way of getting truthful information. To be sure, there is evidence to support the firm's decision to abandon confrontational and accusorial interrogations. In addition to obvious examples like Brendan Dassey's case, there's also empirical evidence. In 2014, meta-analysis of several field and laboratory-based studies, the authors wrote, field studies reveal that both information gathering and accusatorial approaches were more likely to elicit a confession. However, experimental studies reveal that the information gathering approach preserved, and in some cases, increased the likelihood of true confessions while simultaneously reducing the likelihood of a false confession. In contrast, the accusatorial approach increased both true and false confessions. Conclusion: the available data support the effectiveness of information gathering style at interviewing suspects. This is why I have to pee a lot, because I drink a lot. But it's good for you. So drink your water, folks. The consulting firm's shift away from the Reed method is therefore welcome news. However, there are still 3 potential roadblocks standing in the way of this current reform becoming a meaningful reform. First, the obvious problem is that the industry change moves at a snail's pace. God, does it ever. It will likely be years before Wickerland, Zulowski thinking takes full root across police training businesses if history is any guide. Second, the consulting firm will replace Reed with an approach it developed in-house, but the WZ method is deprived of the Reed technique itself. That is, the company is still training investigators to score confessions, just with a sunnier disposition and a slightly more open mind. In short, it's not immediately clear that its replacement will be better. And third, aside from that, there is much larger underlying problem to be addressed. The presumption of guilt takes hold in the detective's mind long before the interrogator begins. It is therefore unlikely that a detective would be able to set that presumption aside and maintain a slightly more open mind when he begins to question his target. Instead, there needs to be fundamental psychological shift in the way that police investigate allegations go from the get-go before they enter the interrogation room. To put it more bluntly, in many of the criminal cases I have defended, the term police investigation is a misnomer. Often there is simply no investigation at all. Rather, the investigating officer simply rushed to judgment, and then his tunnel vision leads him to the correct, only evidence that confirms his pre-existing theory of the case. More specifically, tunnel vision is a natural human tendency that has particularly pernicious effects in the criminal justice system. This process leads investigators, prosecutors, and judges to focus on particular conclusions and then filter all evidence in a case through the lens provided by that conclusion. Through the filter, all information supporting the adopted conclusion is evaluated in significance, viewed as consistent with other evidence, and deemed irrelevant and probative. Evidence consistent with the chosen theory is easily overlooked or dismissed as irrelevant, incredible, or unreliable. On the other hand, this type of quick and easy approach to law enforcement has at least two major benefits for the police. First, it conforms to society's view of justice in today's victim-centered culture, where we are taught to believe the accuser and condemn the accused, without knowing anything about the parties or the evidence. To question truthfulness or even the accuracy of an accusation is frowned upon, as it is supposedly marginalizes the victim, invalidates his or her experiences, or something to that effect. We see that a lot in society and in social media and all that. People jump to conclusions on somebody just because based on the crimes that they are charged that, oh my gosh, there are monsters or whatever, without actually hearing evidence or anything along those lines. I mean, and I don't have any immediate opinions on if Scott Peterson is innocent or guilty. I just know what I heard in the media, and what I heard in the media was that everyone immediately jumped to him being guilty. Like, he was guilty, right? Everyone says that. But that was an immediate jump based on what? Because he was married to the victim, right? She went missing. I mean, I'm sure there's more things to it that came out in court. But up until that point, if you think about it, the media immediately condemned him as guilty. And you can't tell me that the media doesn't play a role in making sure someone is convicted. I mean, look at Brendan's case, for instance. The media was all over the fact that Brendan and Stephen were guilty. But we all know for a fact there was no evidence showing that Brendan did anything. But the media still portrayed it like there was all this evidence, so much evidence. Like, there's this one video that I saw recently where the supporter put together a bunch of news footage, and one of the news things is a lady was saying that in Avery's burn pit there were smoldering bones sticking out from the ash that were still smoking and smoldering by the time police and investigators got there. And we all know that's not false. That's not true. There were no bones in that fire pit. They came like a lot of people over at Foul Play say, they came in a box and they left in a box. There were no pictures taken of bones in a fire pit. There was no bones smoldering in the fire pit. It's all false. But the media, that's what the media reported on. And people believe that to this day over there. People that live in that area remember the case on TV, and they'll tell you oh no, I saw it. I saw them through the news reports, and I remember they said this, and that. And I saw the trial. I saw the trial firsthand. No, you didn't. You saw what the media wanted you to see. Yeah. Question, truth, and this one. Yeah. The second benefit to rushing to judgment is that it saves the police a lot of time. If the police know what they want at the outset, they can find it more quickly and also avoid getting sidetracked with anything that might contradict their theory of the case. In this way, policing is much like shopping for dinner. My trip to the grocery store will be much quicker and easier if I decide up front that I want fast food, go straight to the frozen section, grab a pre-made extra pepperoni pizza, and ignore the vegetables and fresh fish that might make me think about cooking a healthy dinner instead. Bless this man's heart for thinking frozen pizza is fast food. Sorry. I'm like, fast food is not a frozen dinner. Unless he means like fast to cook food. He should have said easy cooking food, something like that. But fast food is not frozen pizza. That's true. A guy kidnapped and murdered my cousin, and he didn't even get charged with that. With what he did, he kept bleeding. And now he got charged with, oh wow. I'm so sorry to hear that, Don. I hope that your cousin finds justice in that. Pleading. Yeah, pleading. I thought it was pleading, but I hope your cousin and your family find justice for that situation, Don. I'm so sorry about that. It's got to be incredibly hard to continue to go through. Yeah, pleading down. Yeah. That's why I don't like plea deals, believe it or not. Whether innocent or guilty, I just don't like them. If you have somebody, like let's say for instance, let's take Brendan's case for instance. So Brendan was offered a plea deal to confess against Stephen. He would have gotten 15 years. That was their plea down, right? And they would have been completely fine and okay if Brendan went to prison for 15 years and then he got out. Like, the state was completely and totally okay with that as long as he testified against Stephen. But because he didn't testify Stephen, now he's getting life. But if you were fine with 15 years, then you should have just gave him 15 years. Like, why life? Like, to me, it's ridiculous to try to plea down. And it's also a trap, too. Like, it's made to make you confess to something that either you did or didn't do. My personal opinion. I just don't like plea deals. I think if you want to sentence somebody to prison for 30 years, then you should sentence them to prison for 30 years. You shouldn't, like, I don't think there should be a deal or a plea down, because then it causes wrongful convictions, and then I don't agree with pleas. What I said probably doesn't make sense either. Oh. My video on Facebook has ended because I played a Netflix. Well, that's a bummer. Accept changes, acknowledge the changes, and the actions. Well, I don't own the rights to it, so there's nothing I can really do. I'll just remove the video. Well, that's a bummer. But you can't do anything these days, huh? Anyway, where was I? The drawback, of course, is that this type of tunnel vision and disregard for actual investigation can lead the police to target and arrest innocent people. I know this firsthand. While it is not always possible, in many cases I have been able to do incredible simple things the police should have done to establish my client's innocence. I'm not referring to cases where I'm able to negotiate plea deal for a misdemeanor and a fine, or cases where I was able to go to trial and win an acquittal. I'm instead referring to cases where I have all but proven my client's actual innocence before trial, and the prosecutor therefore agreed to dismiss the case entirely. Sorry. No, StreamYard's yelling at me. Okay. This can be the best illustrated by examples, subtle variations of which I see on a regular basis in my criminal defense practice. One of my former clients was charged with reckless endangerment of safety, a serious felony, for allegedly threatening another person and repeatedly but unsuccessfully thrusting a long box cutter at the person's head. Like many of the criminal cases filed in Wisconsin, this one involved no actual injury to a person or damage to the property, and it was based solely on the word of the accuser. As in their practice, the police finally accepted the accuser's story, box cutter, knife and all, without learning anything about the parties or looking for any evidence that might contradict the allegation. I, however, was skeptical and was also interested in an alternate hypothesis. More to the point, I first wanted to know if the accuser had made any prior inconsistent statements about what supposedly happened. I therefore obtained a copy of the accuser's 911 call. Something the police could have easily done but failed to do, which was something like this. Operator, this is 911, what's your emergency? Caller, yeah, Johnny Jones just threatened me and I'm afraid. Please send the police, I want to file a complaint against him. Operator, okay, what did he do? Caller, he said he was going to beat my ass, hurry up, I'm afraid he might. He's done it before, he hurt me before. Operator, okay, stay calm, where is he now? Where are you? Caller, he left. He drove off. I'm at 1212 Main Street. Operator, okay, are you hurt? Do you need a rescue squad? Caller, no, he just threatened me. He didn't do anything this time. Operator, I'm sending a squad car. In case the police come in contact with him, I need to know if he has any weapons. Does Mr. Jones have anything like a knife or a gun or any type of weapon? Caller, no, he didn't. Operator, the police are on their way. Stay inside and stay in the line with me until the police get there. See, he admitted that he didn't have a box cutter or a weapon on him, right? Caller, okay. Operator, all right, the police have arrived. They should be at your door any minute. Are they there yet? Caller, yeah, they just got here. Bye. Within 30 seconds of hanging up, the accuser then went on to tell the responding police officers the story of the box cutter knife attack. Let's take a short multiple choice test. Which of the following two options is more likely to be true? A. Johnny repeatedly thrust the knife cutter at the victim's head, but seconds later the victim forgot to mention it and the 911 operator specifically asked, did Mr. Jones have anything like a knife or a gun or any type of weapon? Or B. The 911 operator's question about whether Mr. Jones had anything like a knife is what gave the victim the idea for the story of the knife attack. My money was on choice B. And with a little more investigation into my client's nonviolent background, as well as the accuser's real motive for wanting to get him arrested, I was able to spell out that our defense for the prosecutor. The prosecutor then wisely and promptly dismissed the criminal case before trial. And to the prosecutor's credit, she did not try to squeeze a disorderly conduct and fine out of my client. Instead, she realized the victim was not a victim at all, but had trumped up the allegation for other reasons, and all too common practice among those who take advantage of our victim-centered culture and use the police as their own personal tools. I see that a lot, by the way. People using the police to basically bully and intimidate and harass other people and try to play the victim in it. I see that a lot, actually. And it's kind of gross, and it's really I know a lot of people don't like the whole victim title and stuff like that. Like, a lot of people have issues with that, but it really brings up more stigma behind it when people pretend to be a victim in situations when they're not, and then they use police or whatever to try to manipulate their stories to make it look like they're more of a victim. Because then it's plainly obvious they're not really the victim, and then it just makes them look, it makes other people who actually are victims. You know what I'm saying here? Like, I see it a lot. It's happened to me, actually, even. A few times people have made claims that I bully them and that they're the victim of my bullying when I don't even talk to the person or interact with the person at all. But then people immediately will jump to their side of things because we are a victim-centered culture, and it's not fair, right? Because what else do I have to prove other than just continuing to leave them alone? But like, and then to me, it just makes them look, makes other victims look bad, in my opinion. Does that make sense? So don't do that. What is it? If the investigating officer's tunnel vision was that bad that early in the case, just imagine how firmly the officer would be convinced of those beliefs by the time he gets Johnny Jones into the interrogation room. As a different investigating officer in another one of my cases explained on camera to a victim, okay, we'll go find him, let him tell his side of the story, and then arrest him. There's nothing like a foregone conclusion to start off an investigation. The larger point, of course, is this. Implementing subtle change in how the police interrogate suspects is sort of like putting out a fresh coat of paint on top floor of a building with a rotting foundation. The problem runs much deeper, and is such a superficial fix won't do much good, unless the police are trained to keep an open mind early in the case. Be receptive to the evidence that contradicts the accuser's story, and to actually take some basic steps to collect evidence regardless of where it might lead. Changes in interrogation training are not likely to have any meaningful impact on reducing false confessions and wrongful convictions. All right, and that's the end of chapter 35. Next one is chapter 36. The Dangers of Discourse, 193. The last chapter on legal reform is not exactly about legal reform, but more about educational reform. We should consider educating young people, if not everyone, on the dangers of talking to government agents. The police have done a great job of convincing us that they are friends. For example of this, we need only think back to deputy-friendly grade school. This type of early age indoctrination, its benefits for the police. One is that it eventually creates a culture where people are more likely to trust the police and talk to them, and this remains true regardless of the suspect's age. As I explained in Chapter 10, when I met some of my adult clients, the first thing they do is express absolute disbelief that they have been arrested and charged with a crime. Why the surprise? Because they tell me the detective seems so nice, so honest, I thought he was on my side. There are times, to be sure, when law enforcement is on our side, but that's not always the case. Further, just because they're on our side one minute doesn't mean they'll be there the next. I'm just going to say biasly that the law enforcement are never on your side. Don't trust any law enforcement. And that's all I got to say about that. Never trust the law enforcement. They're not on your side. It is therefore important to understand some basic realities. To begin, the contrary to what police tell their suspects to introduce them to talk in the first place, it's very unlikely that what a suspect says can be used to help his defense at trial. And worse yet, there are countless ways in which a suspect says can be used, either directly or indirectly, to convict them at trial. This is the best illustrated with some concrete real-life examples. First, we saw in Chapter 6 that the Miranda warning tells a suspect that anything he says can be used against him in court. When hearing this, most people rightfully think that if they admit to knowing an intentionally committing a crime, their confession can be used to convict them of that crime. While this is certainly true, there's far more subtle ways that a prosecutor can use a suspect's statement to win a conviction. One such way is that a suspect may admit secondary level involvement, thinking that if he paints himself as being less culpable than his co-actor, he is helping his own cause. Chapter 16 illustrated how Wiegert and Fassbender took advantage of, and probably even created, this misconception in Dassey by repeatedly urging him to blame Stephen Avery. They told Dassey things like, "He was telling you to do it. He used you for this. He threatened you." And one of my personal favorites, "It's not your fault. He makes you do it." As Dassey later learned, however, being less culpable than Avery didn't serve as a successful trial defense. Instead, two or more defendants can be, and often are, convicted of the same crime. Second, in cases where the suspect's statement is not recorded, the police, prosecutor, and judge can misquote the suspect or otherwise twist the statement into evidence of guilt. For example of this, recall the DNA evidence eventually proved Stephen Avery was innocent of the rape and the attempted murder of Penny Bernstein in the 1980s. However, Avery served 18 years in prison before finally being exonerated. And one of the reasons he lost his case at the original jury trial, and again in his appeal, was he talked to the police. In rejection of his request for a new trial, Wisconsin Court of Appeals wrote, "We also note that Bernstein's identification of Avery was corroborated by Avery's statements at the time of his arrest. Although testimony at trial indicated that the police told him only that he was under arrest for attempted first-degree murder, Avery told his wife, who was present at the time of his arrest, that 'they say I murdered a woman,' and asked the police where the lady lived. Since no one had mentioned the fact the victim was a woman, the jury could probably deem Avery's statement to be incorporating the identification." Did Avery really say that specifically? Maybe not. Maybe the arresting officers had heard what they wanted to hear, internalized it, and then repeated it on witness stand at Avery's trial. On the other hand, maybe Avery did say that, in which case he could have had an innocent explanation. He merely and correctly assumed the victim was a woman, and that his statement did not prove or even suggest that he committed the crime. In fact, we now know beyond all doubt he did not commit that crime. If this is the case, the police, the prosecutor, and appellate court merely twisted Avery's word in pursuit of their goal to obtain or affirm his conviction. And also, you got to realize he had a 50-50 shot of being right? I mean, if he said, "They're saying I killed a man," or "I tried to kill a man," then they wouldn't have, cared. But if he said woman, then they would have used it against him, right? So, I mean, he had, like I said, 50-50 shot at it, and he guessed right. So, but that doesn't mean that he did it. Kind of like with the whole "who shot her in the head, Brendan? Who did that?" I mean, it's 50-50 in that scenario. It's either Stephen did it or Brendan. And so Brendan went with Stephen. I guess he could have also said nobody shot her in the head. But then they would have just convinced him to say it anyway, because then they would be like, "No, somebody did it. Somebody did it. It was either you or Stephen." So it was like a no-win situation either way. Right? So he had a 50-50 shot. The same thing with Stephen. Regardless of the precise words Avery uttered, the lesson is painfully obvious. Talking to the police did not help him, and instead probably cost him dearly. This, at least to me, makes it all more baffling why so many members of the Avery family, including Dassey and Avery himself, were so willing to talk to law enforcement after Teresa Halbach went missing. I mean, I don't disagree with that. There's a comedian her father beat into their heads when they were young. They get pulled into the police station and say, "I'm not saying nothing. I want an attorney." Yeah. And that person is right. That's something that I strongly believe that everybody should be teaching their children at a very young age. and to continue to instate that as adults. Third, the most interrogations today are recorded. Overall, this is a very good thing, but it also opens up entirely new ways for the government to use the suspect turned defendant statement against him at trial. For example, in cases where the suspect denies guilt, the police love to shift the burden of proof to the suspect by asking him to prove his innocence. One common way to do this is simply ask why the victim would make such accusation if it weren't true. Or simply, the police can present the suspect with evidence of his own guilt, whether real or fabricated, and then ask him to try to explain it away. And I also want to point out Brendan's interrogations, all of them were recorded. And the one that they used, the March 1st one, was not the last one, but second to the last one. And that was the one they used in court. And even though they recorded it, and even though we can see where a lot of manipulation came in, he was still convicted of what he was charged with. And we all know that that was false, right? That he didn't really do it. So even in that, they were able to twist his interrogation video to make it still, like, look, he's guilty. He did it. He confessed in the tape. Even though they redacted the last 40 minutes, I believe, of the tape. And they didn't see towards the end where his mom came in and redacted his statements immediately. But, yeah. The problem is that the suspect often interprets these as good faith questions, as if the police are honestly searching for the truth and are looking for information that might prove the suspect's innocence. As discussed earlier, however, interrogation is a guilt presumptive process, not a truth-seeking endeavor. Thus, the suspect may play along and speculate about possible reasons why the victim would accuse him of a crime, or search his mind for ways to explain the physical evidence that the police are making up out of thin air. What the suspect fails to realize, however, is that even though he is denying guilt, the prosecutor will later play this video recorded interrogation for the jury. And at trial, the prosecutor will paint the defendant's earlier response to the police questions as ridiculous denial, nothing more than a guilty person's frantic attempt to create a frivolous defense. By comparison, this will make the prosecutor's case at trial seem more stronger. That is, the jury looks at the two competing theories in the case. If conviction of a crime fits the fact better than the acquittal, it is extremely difficult to overcome the desire to match the facts with the better of the two models, even if the state's case is not very strong. So much for the supposed burden of proof. In other words, when the defendant denies guilt and attempts to defend himself in the interrogation room, the prosecutor no longer has to prove his case beyond reasonable doubt at trial. Rather, at least as a practical matter, the prosecutor just has to come up with a theory that sounds better than what the defendant cobbled together off the top of his head when facing the crushing pressure of the interrogation room. Fourth, remember there are two parties to a police interrogation, the suspect and the police interrogator. And playing the interrogation video for the jury is a great way for the prosecutor to backdoor police testimony that he or she never bringing into court through the front door. By playing the interrogation video at trial, even when the video includes the defendant's admitted denial of guilt, the jury will hear the interrogator say things that he never would be allowed to say from the witness stand. Oh, interesting. Interesting. For example, it is well-settled law in Wisconsin and in many other jurisdictions that a witness in trial may not testify that a defendant is lying when he denies guilt. Rather, the credibility of the defendant's testimony is an issue for the jury to decide. In Wisconsin, this is known as the Hazelton Rule, which generally prohibits one witness from vouching from another witness' testimony. And it's a good rule. Otherwise, prosecutors would simply ask their police and detective witnesses whether they believe the defendant is lying. And the detective would invariably testify that he was. This is particularly dangerous given the common but debunked misconception that the police are trained as human lie detectors. But the interrogation video provides a backdoor for this forbidden testimony. At the time of the interrogation, the detectives can call the defendant a liar as many times as he wants. Then the prosecutor can play the video for the jury. In the Wisconsin State v. Miller, the defendant's appellant lawyer appealed a conviction that was obtained by such means. The main concern regarding vouching testimony is that it invades the jury's duty as the sole determiner of credibility. Several times during defendant Miller's interview, Detective Premising stated that Mr. Miller was lying or not telling the truth. Moreover, there are numerous times during the interview when Mr. Miller would answer Detective Premising's questions, and Detective Premising would state that Mr. Miller was lying or would insinuate that Mr. Miller was lying. The interview was played before the jury and received as evidence during the trial. Detective Premising's opinion as to whether Mr. Miller was telling the truth during the interview is a clear violation of hassle time, which makes little difference that Detective Premising did not directly testify whether he believed Mr. Miller was telling the truth during the interview. The effect on the jury was the same or possible even worse. Interesting, right? I never really thought of that. The defendant's appellant lawyer is correct. Nonetheless, the court saw the opportunity to affirm the defendant's conviction by drawing a meaningless distinction. As the trial court observed, Premising's court statements amounted to an unsworn interrogation technique. The court therefore held that because Premising's statements were not made as sworn testimony, but were instead made in the context of a pre-trial police interrogation, the Hasseltine rule was not violated, and the trial court did not err by permitting the DVD to be played for the jury. Finally, even when the suspect denies guilt, and even when the interrogation was recorded to prevent the interrogators from misquoting the suspect, there are still risks. And to illustrate this final point of the chapter, we now can return to Dassey's jury trial, where the government spin machine was operated at high speed. Recall from Chapter 4 that on November 6, 2005, just after Teresa Halbach witnessing, Detective O'Neill and Baldwin got into their hooks into Dassey and interrogated him in the back of the squad car. That interrogation also is up on this channel if you guys want to watch it. Dassey did not say anything incriminating in that statement. Nonetheless, the audio recording statement was used against him at trial. Not for its content, but so one of the interrogators, Detective O'Neill, could wax eloquently about Dassey's demeanor during their exchange. He testified, I interviewed a lot of people, and Mr. Dassey's demeanor was different. When it came to specifics regarding Teresa Halbach, Stephen Avery, what happened on that day, he sat there, head down, withdrawn, motionless, and was a demeanor I felt from all the years of training and experience that I've dealt with people, an inner struggle, a conflict. He was hiding something. It was not going to be a 10-minute interview as to what he saw. There was something more. The detective admitted on cross-examination that he was not trained as a child psychologist or even a psychologist, and that he had never seen Dassey before that day and had no idea how he reacts to stressful situations or to authority figures, and that he wrote nothing about Dassey's alleged different demeanor in his police report. Rather, he was testifying based on his alleged memory of short interrogation that occurred 16 months earlier. Further, O'Neill testified that Dassey struck him as someone who was hiding something. Yet no one bothered Dassey for a substantive follow-up interrogation until Wiegert and Fassbender pulled him from his class nearly 4 months later. And that decision, Wiegert said, was made based on a child's relative opinion that Dassey had lost weight and was behaving differently since Halbach's disappearance. It was Kayla. Only one hopes that jurors are able to see through this sort of government sophistry that the prosecutor and Detective O'Neill were concocting at trial, but that all depends on the individual jury's critical facilities. Nonetheless, the stark reality is that in Dassey's case and in all the examples discussed above, the defendant's discussion to talk to the police did not help, but instead probably did significant damage. If we want to educate people on these types of dangers, we would be wise to look at two sources. One source is the Miranda warning itself. Despite its numerous gaps and flaws, it does make one thing clear. Anything you say can and will be used against you in court. Further, we can include the warning that in addition to what you say, how you say it can also be spun and twisted into evidence of your guilt. As we learned in the earlier chapters, though, the police don't have to read a suspect the Miranda warning unless the police have arrested the suspect and intended to question him. Therefore, it'd also be wise to remember that unnecessary but accurate warning Fassbender uttered to Dassey before questioning him at Oshkosh High School. You're not under arrest. You know that. You're free to go at any time you want. Just listen to us. We don't have to answer any questions if you don't want to and stuff like that, okay? Had Dassey said, okay, I don't want to answer any questions, I'm going back to class, or, okay, then I'd like to have my mom or lawyer present before going any further, he could have avoided being charged, tried, convicted, and imprisoned, all without an eyewitness, a piece of physical evidence, or even an accusation linking him to the crime. While on the topic of imprisonment, let's turn to the book's final section and see what has been happening with Dassey's case, which we already know what's been happening since this book. So this book was written right before he went to the Supreme Court. So he's gonna talk. This is the last part, last chapter, last 3 pages so it might get a little sad here because he's talking about what could happen, and we already know what happened, unfortunately. But postscript. So chapter 37, Calling the Supreme Court. This is the last chapter, guys. I'll take my case all the way to Supreme Court. That phrase has been uttered by countless people ranging from disgruntled losers in small claims court all the way up to huge corporate litigants in federal courts of appeal. But the reality is that it's incredibly difficult to convince the Supreme Court of the United States to actually hear any given case. Nonetheless, against all odds, Dassey's appellant lawyers are trying. After this book was completed, but before it went to press, Dassey's appellant team, which now reached to the total of 10 lawyers located in 5 different states and Washington, D.C., filed a lengthy petition for a right of certioria, Latin word, with the court. In it, they asked the court to accept Dassey's case for review, and they've highlighted several selling points. First, they illustrated how Wiegert and Fassbender used egregious interrogation tactics to take advantage of Dassey's deficiencies and coerce a confession. They capped off this lengthy analysis as follows. Put simply, the interrogators took advantage of Dassey's youth and mental limitations to convince him they are on his side, ignored his manifest inability to correctly answer many of their questions about the crimes, fed him facts so he could say what they wanted to hear, and promised that he would be set free if he did so. The resulting confession was more theirs than his. Extract through the use of psychological coercive tactics levered against his personal vulnerabilities. It was assured not the product of Dassey's free will. As Dassey himself said to his mother just moments after the interrogation ended, they got to my head. Second, they explained why the state's appellate court 2-paragraph recitation of some cherry-picked facts, along with his citation of only a portion of the equitable legal standard, falls short of what the law demands. In other words, to use the language of the AEDPA, discussed in earlier chapters, the state's course discussion was not merely wrong, but so wrong that it must be reversed. The state's court utterly failed as part of its totality of the circumstances analysis to afford Dassey's confession the special care this court requires for juvenile confessions. More specifically, just listing a defendant's particular characteristics does not pass the test, nor is it adequately mere to jump to the conclusion that the confession was voluntary. Instead, the actual legal analysis, the very thing for which Wisconsin's appellate court judges are grossly overpaid, is required. Yeah. And when analyzing the facts and circumstances, not every circumstance is equally important. For example, the upholstery on the couch Dassey sat on during the interrogation was simply not as important as Dassey's mental limitations and meager and Fassbender's dozens of threats and false promises of leniency. The appellate court team also sold the court on the national significance of this case, a case that isn't just about Brendan Dassey. Rather, coercive interrogation tactics are widespread, and the false confessions they produce are a national-wide problem. Worse yet, state courts are ignoring blinding Supreme Court precedents that are instead rubber-stamping convictions, even when the prosecutors win those convictions by using obviously coercive confessions. The court therefore needs to remind these lower courts of the importance of stare decisis, their duty to follow binding precedents. The Wisconsin Court of Appeals, apart from this court precedent, is no isolated incident. Since the court decided Gallegos, Galt, and Fair, lower courts have often failed to follow those decisions. The consequences of those failures have been illustrated not only by research demonstrating how vulnerable juveniles and intellectually disabled persons are to police interrogation tactics, but also by data on wrongfully convictions resulting from false confessions. Certiorari is warranted here not only to refrain from this court's holdings and lower court's obligations to follow them, but also to provide guidance on how to apply those holdings as to minimize the false confessions, which not only led to innocent people being jailed, but also leave the perpetrators free to victimize others. While the Supreme Court could be persuaded to hear Will the Supreme Court be persuaded to hear Dassey's appeal? The odds are certainly against it. However, in a bizarre roller coaster case like this, a case with unbelievable facts, an obviously coerced and false confession, unparalleled national and even international popularity, and a very unusual procedural history, it's difficult to rule out the possibility. In other words, the case certainly has anything could happen or about it. On the other hand, if the Supreme Court refuses to hear Dassey's case, this much is certain. The interrogation and conviction of Brendan Dassey will go down as the greatest injustice in the history of American criminal law. And that's the end of it. That is probably the most powerful paragraph. Like, I got chills because it's just so true. If the Supreme Court refuses to hear Dassey's case, this much is certain. The interrogation and conviction of Brendan Dassey will go down as one of the greatest injustices in the history of American criminal law. And it's true. The Supreme Court never did listen to Brendan's case. And it was thrown out. So that's what happened with that. And like he said, it's so far has been one of the biggest, I feel like one of the biggest American tragedies in the justice system. One of, there's multiple things that are going on, but I think what happened to Brendan Dassey is just absolutely heartbreaking and criminal and it's just so messed up and so obviously wrong, and yet he's still in prison. So I don't, and all we can do is just keep pushing and keep writing and keep tweeting and keep calling and keep mailing things, and it makes me incredibly sad this year that there isn't going to be a rally. For my own stream. Okay, sorry. It makes me incredibly sad that it looks like we're not going to have a rally this year, at least in person. And you know, I'm still gonna do an online rally, and hopefully maybe something will happen in person, but it just doesn't seem like it right now. Nobody's really interested in throwing the rally. I'm probably gonna be messaging the powers that be and just letting them know I'm gonna be planning next year's rally now, just so that we can get it on the books and ready to go for next year. But as of this year, one person did go out to Madison on their own accord and stood out there in front of Governor Evers with a sign, and they wanted to remain anonymous in that, which I completely and totally respect. But they did do that for 2 days, and I think they are awesome, and I do want to say thank you to that person who did that, because that is very powerful. And I wish I could have been there in person to stand with them, but unfortunately, this year for me has been very busy with family obligations, like my niece's surgery, and then my mom had her surgery, and then in December my sister's getting married, so my funds are kind of going towards that stuff right now. So, but next year, if Brendan's still and where he is, and unfortunately, he very well could be, but you know, maybe something will happen, but I'll be out there, and I'll be doing another rally, and I'll do Madison and maybe Manitowoc. We'll see. You know, maybe I'll just do Madison. I don't know. But yeah, that's kind of what's happening with that. So thank you everybody for listening to me read this book, and like I said, you guys should pick it up and buy it too from Amazon. That's where I got it. And next Monday, we will be reading from, let me see. Let me move some stuff around. Get this book out. Let's see. I think I want to read this one. Convicting the Innocent, where criminal prosecutors go wrong. Or criminal prosecutions go wrong, by Brandon Lee Garrett. I got this book. Does it look interesting? It has hold on. There's a lot of pages in this book. Not a lot of pages, but hold on. It has a big appendix like the other book does, because it's mostly notes and statistics and stuff like that. It's got 274 pages in it. And, I don't know, it just looks like an interesting, oh, look, a bookmark. Iron Cutting Enterprises. Somebody left a thing in here. That's funny. Kendrick Henderson, aka Supreme Intellect. Looks like he's a rapper of some sorts. That's funny. Here's another bookmark somebody left in here. Well, I'm gonna get rid of this Supreme Enterprise bookmark. Oh, you can't even tear this. It's like plastic. I'm gonna throw it away. And I'm going to use this bookmark that somebody gifted me. Donna H.A. from Canada sent me a dragonfly bookmark. So I'm going to use this. It has a dragonfly on it and it's got purple. It's my favorite color. So this is going to be my new bookmark in this. Alright, so that's basically where I'm going to leave you guys off at. Thank you everybody for listening, for participating, for subscribing. Please make sure you like, subscribe, share the video out so I can try to get my subscriptions back up again, subscribers back up again. And yeah, thank you all for being here and supporting Brendan. And I know it means the world to him to have an army full of people who love and care about him. So I thank you all for that too. And I will be ending with this one.